On this week's episode of the Crushing Debt Podcast, can the bank collect after issuing a 1099-C?
Welcome to the Crushing Debt Podcast with your host, Florida attorney Sean Yesner, where our goal is to help you get rid of the financial bullies in your life.
So welcome back to this week's episode of the Crushing Debt Podcast. My name is Sean Yesner of Yesner Law. This week's episode is brought to you by Polly Bauer & Associates. They specialize in teaching you how to grow your business through the right payment methods, providing e-commerce education and expansion strategies, and educating you on the value of early detection and prevention of fraud. You can learn more at www.pollybauer.com, and make sure you check out Polly's podcast called Swipe the Podcast with Polly B. So I had an interesting issue come up here in bankruptcy court, and I thought I would bring it to all of you to see what you think. Now, it has to do with a 1099-C, and I discussed 1099s, and I discussed the Mortgage Debt Relief Act way back in episode 24 when we were called the Yesner Law Podcast, before I did the name change and the brand change over to the Crushing Debt Podcast. I talked about the Mortgage Debt Relief Act, and you can go check out that episode on our website, yesnerlaw.com. But I had an interesting issue arise in bankruptcy court. So I had a client who modified their mortgage. And the way the bank modified the mortgage was they took the mortgage modification amount and they put it at the back of the loan. So the borrower was going to make regular mortgage payments again, and then when they sold the house or when the loan matured, they were going to have this big lump sum of money that was owed. And after a certain number of payments, after a certain number of years, the bank then forgave that amount of money. So the bank said, that big chunk we put at the end of the loan, borrower, you no longer have to pay it. And so when that happened, the bank issued a 1099-C. Now, the whole premise behind the 1099-C is it is cancellation of debt or forgiveness of debt income. So the way that I explain it to clients is, if the bank eliminates debt that you owe, the IRS pops up and the IRS says, well, wait a minute, you got a benefit. You got a benefit because you're legally obligated to make those payments, and now the bank has waived its right. The bank doesn't want those payments, and so you got a benefit. You got a benefit because you don't have to make those payments. And anytime you get a benefit, Uncle Sam wants his cut, and so you potentially have to pay tax on that forgiven debt. So if you have, I think in this case it was like $120-something thousand that had been put at the back of the loan that the bank ended up waiving. And so in that case, they issued a 1099 for about $124,000. The borrower had $124,000 of what we call phantom income. Now, the Mortgage Debt Relief Act was a way to eliminate that income. So you would not pay tax on any of that income if it was based on the short sale or foreclosure sale or forgiveness of debt income related to your primary residence that was used to buy or improve the house. Now, as of this recording, the Mortgage Debt Relief Act no longer exists, although I understand there are a couple of our legislators that have amendments to different bills that might bring the Mortgage Debt Relief Act back through the end of 2018. But at least as of this recording, there is no more Mortgage Debt Relief Act. But for this particular client, back when the bank did waive that loan modification, the amount of the loan modification they put at the end of the loan, the Mortgage Debt Relief Act was in place. And so this particular homeowner didn't have to pay tax on that money, which is a great thing. Now, fast forward a few years to 2017, and the forgiveness of debt, the loan modification and the forgiveness of debt, I believe, happened in like 2013 and 14. So now, fast forward to 2017, unfortunately, our borrower has again fallen behind on his loan. And so in this time, in order to catch it up, because the bank wasn't going to modify it again after they had modified it in the past, to catch it up this time, we filed a Chapter 13 bankruptcy. And so the plan was we were either going to modify the loan within the Chapter 13 bankruptcy, or we were going to use the Chapter 13 bankruptcy to catch up whatever was past due. It wasn't a very large amount when we filed. Well, when the bank filed their claim, they included the amount that they had waived. They included the amount that they had given the borrower a 1099 for. They had given the borrower, they had included in their claim and the amount of money that they were owed, the amount that they had forgiven 3 or 4 years earlier. Now, here's the issue. we have a split of authority between the states. And so there's a couple of court cases out of Pennsylvania that say that the 1099 is only a reporting tool. The 1099 is not itself a waiver or a cancellation of the debt. And so if we had relied on Pennsylvania law, my client loses, and that amount is allowed, and that's the amount of the claim that he has to pay, even though he had waived it earlier. Now, in that Pennsylvania case, what the court said was that if that causes harm to the borrower, then the borrower's remedy in that situation is to amend his or her tax returns to show that the amount was not actually forgiven. So Pennsylvania goes in favor of the banks. There was a later case out of Tennessee that said, wait a minute, wait. This is all garbage. If the bank waives the debt, the bank waives the debt. I don't care if they issue a satisfaction. I don't care if they issue a modification. I don't care if they issue a 1099. If they issue a 1099, that means they forgave the debt and they cannot come back later and try to collect it. So Tennessee is good for us. Tennessee says that the 1099 is evidence that the bank waived and cannot any longer try to collect on that debt. Now, to my knowledge, that hadn't occurred, that scenario hadn't occurred in Florida, and I couldn't find any case law in Florida that said what Florida's position was on the issue. I couldn't find any case law here in the 2nd District, which is where Hillsborough and Pinellas County, where Tampa Bay is located, where any judge here in the Tampa Bay area had ruled on it. I didn't find any state cases in Florida that ruled on it. I didn't find any cases out of the 11th Circuit, which is up in Atlanta, which covers Atlanta and Alabama and Florida. I couldn't find any case law on this issue in this area at all. The only cases that I could find were the Pennsylvania case and the Tennessee case, which went both ways, went each two different directions. And so typically what that means is we have to certify the question to the Supreme Court, to the U.S. Supreme Court, and let the U.S. Supreme Court determine the difference between the states. Basically, let the U.S. Supreme Court determine which state is right. But I didn't have time to do that. I had a bank that was filing a claim that said that they were owed money that they had previously issued a 1099 for, and I thought, okay, good. Finally, I may be able to make some new law here and argue for the borrower within Florida, maybe get some of the consumer advocate groups behind me to help me issue briefs and arguments and whatnot. And this was in the context of bankruptcy. And so I was going to be able to do it in a federal court context, which then creates the opportunity, if we can figure this out, to maybe get this issue in front of the Supreme Court. And so I got all excited and I started creating all of my arguments and my oral arguments and collecting all my data and collecting all my cases. Initially, the bank fought me on it. The bank started to ask about, well, how did the borrower report this on his tax return? And what did the borrower do with the 1099? And show us that the Mortgage Debt Relief Act applied, and show us that the Mortgage Debt Relief Act, that the proper forms were filed with the borrower's 2013 and 14 tax returns to show that all this is correct. And my response to the bank was basically, all that stuff is nice, but it's all irrelevant. The borrower's treatment of the 1099 is irrelevant to whether the bank can try to collect it or not. Now, here's the interesting issue, or here's the unfortunate issue maybe for my listeners here, maybe for all of you listening right now, is that when I pushed the issue and I stood my ground and I didn't give in, the bank eventually, in a big game of chicken, amended its claim to remove that 1099 forgiveness of debt income. So the bank basically conceded, which I think means that in this case, the bank didn't want to risk having any negative case law against it. So in that scenario, I guess it's a win for me. It's a win for my client. The bank ultimately unwound their claim and took that money, that $125,000 out of their claim. So that's $125,000 less than my client owes the bank, at least in the claims that it filed in bankruptcy court. So in that scenario, a win for me, a win for my clients. Good job. A little part of me is upset or sad that I didn't get to argue it in front of the judge and didn't get to try to make new case law in front of the judge. But in terms of creating a favorable outcome for my client, I will take it. So how many of you have ever experienced a situation where you received a 1099 for the forgiveness of debt income, for cancellation of indebtedness income, and then later received a collection call from somebody wanting to collect on that income. We do have some argument that is improper, and that's something that we can challenge. So if you find yourself in this situation, or you know people that find themselves in this situation, let me know, and we can always go after them. You can reach me at Shawn, SHAWN, at yesnerlaw.com, YESNER law.com. But I think that pretty much wraps up this week's episode of the Crushing Debt Podcast. I hope you enjoyed this sort of quasi-tax bankruptcy analysis. And if you know anyone in this situation, certainly send them our way. And we look forward to talking to you in next week's episode of the Crushing Debt Podcast.
If you have questions that you think would make a great topic for a future episode, please email Shawn or connect with us on social media. Shawn Yesner and Yesner Law, PL, are Florida licensed attorneys. The information contained in this week's episode is not a substitute for legal advice. Your situation may differ, especially if you are located somewhere other than the state of Florida. If you have questions, please contact our office or contact a local attorney. Thank you for listening to this week's episode of the Crushing Debt Podcast.